Okay, testifying in court. Just hearing those words is enough to make most people's palms start to sweat, right? But what if you could swap all that anxiety for some real confidence? Well, today we're going to walk through a pre-trial checklist that does exactly that. It's designed to turn the stress of the witness stand into a solid, clear plan for success.
So the call comes in, you have to testify, and suddenly, bam, your investigation, your methods, pretty much your entire professional reputation, it's all on the line. I mean, it is high stakes, it can be really intimidating, and it feels like even the tiniest little mistake could have huge consequences.
In a situation like that, being prepared isn't just, a good idea. It is your single greatest asset. So think of this as your pre-flight checklist. It's designed to make sure you're ready for anything and everything that courtroom is going to throw at you. Okay, so let's get into it. We're going to cover 5 crucial steps. First, we've got the essential meeting with the attorney. We'll call it the attorney huddle. Second, mastering your own case file. Third, crafting your courtroom persona. Fourth, what to do when you need to prove your expertise. And finally, the last-minute check that could seriously save you from disaster. First up, the attorney huddle. Now listen, the #1 rule of testifying is super simple. You never, ever, ever walk into a courtroom cold. Your first stop always has to be a pretrial conference with the client's attorney. So what actually happens in this meeting? Well, for starters, the attorney is going to walk you through the questions they plan on asking you on the stand. That's what's called your direct examination. But honestly, what's even more important is that they're going to play devil's advocate. They'll hit you with the tough, awkward questions the other side is probably going to ask. The point isn't to freak you out. It's to make sure that when you're up there, nothing comes as a total surprise. And this brings us to a really critical line, an ethical and legal line that you absolutely have to understand. Preparation is totally legal and necessary. It's all about discussing the facts of the case and figuring out the clearest way to explain them. Coaching, on the other hand, is illegal. That's when an attorney tells you what to say or asks you to lie or to change your story to fit their narrative. It's a huge no. And let's be crystal clear about this. This is an absolute, non-negotiable rule. If an attorney ever asks you to lie or to fudge the truth, you have only one move. You refuse, and you withdraw from the case. Period. Your integrity is everything. All right, let's move on to our second point, mastering your own file. So, you've met with the attorney, and now your focus has to turn inward. This is more than just a quick reread. We're talking about a total memory refresh. Just think about it for a second. Trials can happen 2, sometimes even 3 years after the original investigation. Do you remember every specific detail from a case that long ago? Of course not. Nobody does. And that's exactly why digging back into your own file isn't just a good idea, it's absolutely mandatory. And here's a super simple protocol to follow. Step 1, read everything. Not just your clean, final report, but also your messy handwritten notes, your surveillance logs, all of it. Step 2, look for your own mistakes. Find any typos, any wrong dates, any inconsistencies. Because trust me, you want to find them before the other side's lawyer does. And that leads to step 3, which is crucial. If you find a mistake, you tell your attorney about it immediately. That way they can deal with it head on and it takes the weapon right out of the other side's hands. Okay, let's talk about a classic courtroom trap that you really need to avoid. In many courtrooms, there's what's called a use of notes rule, and it's brutally simple. If you bring any document to the stand with you, the opposing counsel gets to read it. So what does that mean for you? It means you absolutely cannot bring your entire messy, disorganized case file up to the witness stand with you. The strategy is simple. Bring only your clean, final report, and maybe a few specific documents you've already discussed with your attorney. Nothing else. All right, so you've completely mastered the facts. But that's only half the battle. Now we've got to talk about perception. Section 3, the courtroom persona. And you have to remember, you are being judged from the moment you walk into the courthouse, not just when you sit down in that witness chair. I mean it. Your appearance and how you carry yourself send a really powerful message. For your clothes, think conservative business attire. No sunglasses, no tactical gear, nothing flashy. And when you're out in the hallways, in the elevator, or even in the bathroom, do not talk about the case. You have no idea who might be listening. And then on the stand, your body language says it all. Sit up straight and project a professional, confident posture. Now, when you're actually on the stand, it is so easy to get laser focused on the person asking you questions. The lawyer asks a question, but here's the thing. They aren't the person you actually need to convince. The jury, they're the ones with all the power. They are the ones who decide the outcome of the case. So here's the technique, and it works. Look at the attorney when they ask the question. That shows you're listening. But then physically turn your body just a little and deliver your answer directly to the jury. Make eye contact with them. You're not just talking at them, you're talking to them. It makes a huge difference.
But hey, what if you're not just a witness to the facts? What if you're there as an expert witness? Well, that brings us to our fourth section, proving your expertise. Before you can even give your expert opinion, you have to get through a process called voir dire. It's pronounced voir dire, and it literally means to speak the truth. But in the real world, what it means is it's a preliminary showdown where the opposing lawyer gets to challenge and attack your qualifications. Their whole goal is to try and convince the judge not to officially declare you an expert witness. Your shield during this whole process is your curriculum vitae, or your CV, and it has to be perfectly up to date. You need to include any professional certifications you have, things like PCI or CFE, your years of experience, the number of similar cases you've worked on, any specific training you've taken, and, this one is huge, a list of every single previous case where a court has qualified you as an expert. Okay, we've made it to our final section, the final check. Look, these are the last-minute details that can trip up even the most prepared witness, so you gotta pay attention here. So you got your subpoena in the mail, but did you actually read the fine print? Because there are two main types you need to know about. The first is ad testificandum, which basically just means you have to show up and testify. But the second kind, a duces tecum subpoena, is totally different. That one commands you to bring specific documents or files with you to court. And this is exactly why reading that fine print is so critical. If your subpoena says duces tecum, and you just show up empty-handed, you haven't just made a simple mistake. You have actually disobeyed a direct order from the court, and you can be held in contempt. It's that serious. So when you put it all together, you've met with the attorney, you've mastered your file, you've got your courtroom persona down, and you've checked the fine print. You're no longer just showing up to answer questions. This whole checklist, it isn't just about defense. It's about building credibility. So the final question really isn't, are you ready to testify? It's, are you ready to be believed?